Hi there, everyone. Good afternoon or good morning, depending on where you are. I am Sephton Leibbrandt, an associate at Samfiru Tumarkin, and this is Employment Law Live, where we are answering your questions about anything ranging from terminations, constructive dismissals. Maybe you have, issues with your workplace in terms of bullying, harassment, anything like that. We are here to help you. Thank you for joining us this afternoon or morning, depending where you are. If you are in Ontario, if you are in BC, if you're in Alberta, we can help you and assist you with your employment law concerns. We are be answering a number of questions today, hopefully providing insight into a number of situations to help anybody who has any concerns with their employment, to get the answers that they require with respect to, especially their severance packages, and determining that those packages are fair. So thank you very much for joining us again. If you're just tuning in, I'm Sephton Leibbrandt, an associate with Samfiru Tumarkin. And if you have any question about your employment in terms of your situation there, we are happy to assist you with that. And I'm happy to answer your questions today and hopefully provide you with some insights. I already see that some questions are coming in here, but to start off with, there's an important topic that I think is worthy of initial discussion here before we get into everything, and that is a great deal of you know confusion sometimes about contractors and employees, and this is an extremely common, extremely frequent issue that I often receive questions about. Um, and the difference between the two, whether one is a contractor or an employee, is very significant in terms of the severance entitlements that one has. If you are an employee but have been misclassified as a contractor, you will have substantially greater severance entitlements, very significant severance entitlements as an employee. And in comparison to a contractor role, you may not have any whatsoever at all. So those are very, very important things to discuss. To basically boil it down here very quite simply, and this is a very common question that we receive. If one is an employee, can think of it this way. Basically, if I have a handyman and the handyman comes around, comes to my house, but also has a number of other clients that they go to, then that person is really in business for themselves. They're looking out for themselves and trying to make a profit and grow their business. But if it was the case that I have my own personal handyman, I'm that fortunate, if I was that lucky, that they only come to my address, they only work for me, they have my business card, my number, everything like that, and they're only showing up regular hours at my workplace, then that would be the case that they would probably then be my employee and not an independent contractor instead. And so again, really the key here is things like the nature of your employment. If you've been structured as a business, for instance, that may not be relevant as to whether you are actually potentially an employee at law. So really things like the control and direction that your employer exercises over you, whether you have fixed hours of work, the location in which you work, your position, your title within an organization. All of those things are very, very important in determining, one way or the other, whether you may in fact be an employee and have been actually misclassified as a contractor, which again is very, very common. But one wants, of course, to be classified as an employee, and correctly so, because the entitlements and protections and rights that employees are afforded are far, far greater than contractors are. So very, very important topic to discuss. Again, if you're just joining us here, I'm Sephton Leibbrandt, and I'm an associate with Samfiru Tumarkin, and we are live right now answering your employment questions, any concerns you may have. Um, Jumping very quickly back to independent contractors versus employees. If you are concerned that you may be a, maybe misclassified, you've been terminated, and your employer tells you, hey, you're not entitled to anything, you're a contractor. If you're concerned about that, of course, you can reach out to us at employmentlawyer.ca. That's employmentlawyer.ca. Or, of course, we actually have a tool that you can go and quickly try to determine for yourself. And it's, of course, completely anonymous, to go and determine, whether or not you're an, a independent contractor, a contractor rather, or an employee. And that's at pocketemploymentlawyer.ca, pocketemploymentlawyer.ca. You can find out there and determine for yourself whether you may have additional rights, and you've in fact been misclassified as a contractor when you are in fact legally at law an employee. So that's just one thing I'd like to say, finalizing on that point. Now I see that we have some questions, coming in here, and I appreciate those questions. Excited to get to them and answer them now. So our first question from Ron, 2020, says, my employer wants me to move into a lower position and lower pay, but I can't do this. I need my salary. What can I do? So, Ron, this is, a not uncommon situation. Probably the first thing you would want to do, of course, is you, of course, have no obligation to, reduce your position, change your position, or lower your pay. Those sound like material changes, to me potentially. But the first thing you definitely want to do is reach out to our team, employmentlawyer.ca, or help@employmentlawyer.ca, one of those two, and have, speak to our team, and we can assist you in determining exactly what's going on here, the nature of those changes that have been made, and determining whether, in fact, there may be a constructive termination that has occurred here. But the short answer is, Ron, of course, there is no obligation on you to take a demotion, what it sounds like here. No obligation on you to take a lower rate of pay. As you correctly assert, your pay is what it is, your salary is what it is, you're entitled to that. If your employer is trying to force you to take less, you do not need to do that. Reach out to somebody to our team so we can help you go through this. We have lots of people to speak with and get you the assistance you need to determine which, what exactly is going on here. Is there potentially, a claim for constructive termination of your employment? So please reach out to us about that. We are happy to answer your question, in more detail once we know the exact details of your situation. So I see we're getting a number of more additional questions here, which is fantastic. And just in case you're tuning in right now, I'm Sephton Leibbrandt. We are the employment lawyers, and this is a live Q&A answering any questions that you may have about your employment situations and circumstances, ranging from constructive dismissals that we just touched upon, to terminations, to other harassment, bullying in the workplace, and things like that, medical issues, so on and so forth. Any issue that you're experiencing in your employment, we are, of course, happy to answer those today, and we will try to get to all the questions in the time that we have here. And we still have lots of time, which is wonderful. So the next question that I see here is a question, looks like from YouTube. Marianne wrote, I took a remote position during the pandemic and have been working from home for 3 years. Recently, our company has said that they are changing protocol and want everyone to be in the office at least 2 days a week, but I cannot do this. My agreement was never for in-office work. Can they let me go if I refuse? So if it's the case that your initial contract, Marianne, was only for remote work, and that's in fact, stipulated, for instance, in the contract somewhere, then it sounds to me like no, you do not have to go and go back into the office if that was the agreement that was made. Especially if you've been doing it for the last 3 years as well, it certainly bolsters your arguments that this is a material change to the terms of your employment, and there's of course no obligation for you to accept a major change to those kinds of terms and conditions. But of course, we want to see exactly what the situation is here, to see the contract, until of course we see the contract and determine for ourselves which way this exactly and what's stated in the contract what's being said in the provisions and so forth. Once we see that, then we can determine for great for certainty, of course, is this very definitely a material change in your employment. So you would certainly want to reach out to us at an employmentlawyer.ca. Reach out to our team there and have them look at it, and of course we can help you assess the situation, determine whether or not this is in fact, again, maybe another constructive termination situation. If you refuse to go back into the workplace, again, it wouldn't be really your refusal of doing so. You had a contract, there was an agreement with the employer. The employer sounds like they want to change that contract now in a material way, and they cannot do that. So please reach out to us, Marianne, and we are of course happy to assist and get you certainty and determination on this, and whether again there's maybe a constructive termination of your employment that has occurred here. But again, that's another broader topic. Very, very important that you ever feel that there is a significant change that's being happening, that's occurring in your workplace with respect to your employment. Change in your hours of work, for instance, they would allow you to work on weekends or on evenings. You've never worked that in that capacity before, or change in your position, demotion, or especially a significant change in your rate of pay. All of those things are very, very significant changes potentially that could potentially indicate a constructive termination. If you're experiencing anything like that, or even in this case, as Marianne noted, she's been working for 3 years remotely. Now the employer wants her to come back into the workplace. Don't just simply accept it and take it as it is. Reach out to us to get the clarity that you require on to get a firm answer, a clear answer on is there potentially a constructive termination of your employment that is occurring here, and maybe there's action that you need to take as a result of that. But certainly just don't let it go by the wayside. Unfortunately, I see many people that months down the line, they come back to me and they ask me about something that's happened almost a year ago or something along those lines. And unfortunately, it becomes much more difficult the longer the time goes on, and time passes, to go back and deal with something that happened months and months ago, and to demonstrate that that was a material change, and it should have been acted upon then. So if you're ever concerned, the long and the short of it is, reach out to us, reach out to our team, and get a clarity and confirmation on what the changes that's occurring to your employment is. Is it a material enough change to trigger a constructive termination? In which case, you'd be entitled to severance based on a number of factors that, of course, we will assess for you and assist you with. So please, again, reach out to us in that regard. So thank you for that question, Marianne. A very useful question about remote work. People have been working remotely. In my view, if you've been working remotely for many years, especially if it's in your contract, in my view, that is a substantial material change to your employment, and something that definitely needs to be assessed to determine whether you're owed a severance package. So thank you for that question. Moving on to another question here. If you're just tuning in, again, I'm Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers answering here today for the next 15 minutes or so your questions live, and getting you the assistance and advice that you require and insights into your situation. Please feel free to enter a question into the chat box below, whatever platform you may be on. It's completely anonymous. You don't need to share particulars about your employment, particulars about your situation. Just simply a broad overview of the question that you have. What exactly is it, is generally occurring here is more than sufficient to help me, answer your question today. So thank you very much again, Marianne, for your question there. Our next question here from Emma. Emma from YouTube asks, how soon after losing my job should I contact an employment lawyer? What is the time frame to potentially sue my former employer? So Emma, thank you very much for that question. The answer to that is immediately, as soon as you have been terminated, there's been a termination that's occurred, or your job is ended for whatever reason, you should immediately reach out to an employment lawyer. Immediately reach out to our team at employmentlawyer.ca to get the advice and guidance that you require on your severance entitlements. Because basically, if you have been terminated, you are entitled to severance. It's really that simple. Call us, call our team, get in contact with us. All the information is there on employmentlawyer.ca. All of our contact information. Please reach out to us. Don't leave it. Don't let it go. Don't just simply accept the situation as it is. Get your questions answered. Get your the insight that you require about your severance entitlements. Certainly do not sign back any release, for instance, that the employer has given you with respect to the package that they have offered upon termination, if any, because the fact is, almost all the time, especially that I see, those packages are almost always going to be deficient and less than your actual full legal entitlements at law with respect to severance. So please reach out to us and get the correct advice on that situation while it is fresh, while it has just occurred, while it's on everybody's minds, including the employer's mind. It's the best time to do that as soon as possible. In terms of the time frame to commence litigation, that's a separate issue. Really, the vast majority of the matters that we deal with, that I deal with, can be resolved by a simple negotiation with the employer's legal counsel. So really, even then, if it's litigation is actually necessary, the employer is being unreasonable, even then it's quite a quick process, a few months. But really, the vast majority of cases, matters that come to me that I deal with, those can be resolved and addressed, negotiated, quite rapidly, and to get you, more severance, get you the severance that you deserve for your service to the employer here. So thank you for that question. A very useful question, important question. Long and the short of it, don't sit idly by, don't sit on your hands. Take the action, take the first step. It's completely anonymous. Basically, you can reach out to us. We require very little detail initially, names, things like that, but speak to somebody at our firm who can assist you in determining exactly what severance you may be entitled to. If it's the case that you simply want an assessment of what severance package you may be potentially entitled to, you can do that even confidentially and anonymously at pocketemploymentlawyer.ca and use our severance calculator to determine there exactly how much severance you potentially may be owed, and to assist you in determining that, we require basically very minimal information to determine that and to have that initial assessment made. And then from there, at that point, we can then assist you further. You can speak with somebody. You have all our contact information there at employmentlawyer.ca so that we can assist you to determine what your severance entitlements are in the circumstances. So thank you, Emma, for that question. If you're just joining us here, we still have lots of time. Thank you for all these great questions. Very happy to see the number of questions that are coming in today. And our next question here is from A. Brown. He says, my sister is working for a US-based magazine company. They have said her employment is at will and they didn't owe her any severance. Is this true? They let her go after 5 years as a manager. So the long and short of this, Mr. Brown, is simply that if she worked in Ontario, for instance, or Alberta, or in BC, I'm not exactly sure where she may be be placed, but as long as she worked in Canada, in one of the provinces where we of course generally assist with, that then she would be entitled to a severance package. Her employment, there's no at-will employment in Canada, and certainly not in Ontario or Vancouver or in Alberta. Very, very simply, she should reach out to our team to have a specific assessment done of her contract, for instance, and her severance entitlements. And of course, she can reach us at employmentlawyer.ca and to get a assessment there of her severance entitlements. But the long and the short of the answer is is she at will employment? Absolutely not. If she's in Ontario, if she's in Alberta, if she's in Vancouver, no, there's no such thing as at will employment in our provinces there, and not in Canada. And so she should absolutely, after 5 years of service as a manager, that would typically be a significant severance entitlement. Generally, management level employees receive even more notice because of the seniority of that kind of position, because of the difficulty in locating such position. And so she should absolutely reach out to our team to get a full assessment of her circumstances and in terms of what her full legal entitlements are to a severance package, because they are likely significant, and they are certainly not zero as would be provided by her employer here, suggesting that her employment is at will. Again, there's no such thing as at will employment in Canada. If she's in Ontario, if she's in Alberta, if she's in BC, then she is entitled to a severance package. It's that simple. So thank you, very much for that question. Again, very, very important question, because there's many employers that I deal with all the time that are U.S.-based employers, and they initially may not grasp that people who are actually working and residing in Canada, and as long as they are doing so and they reside in a province in Canada and not in the United States, and don't work in the United States, then the situation is that they will be protected by the rights that we have here for employees. For instance, in Ontario, the Employment Standards Act, and so those people absolutely are entitled to severance, no question about it. It's simply a question of how much it is based on a number of factors. For instance, management position, seniority of position, years of service, age, and things like that. And that's why, again, if you have any curiosity about you've been terminated and you believe you're owed a severance package, you just want to get an initial assessment of what how much you may be owed, please go pocketemploymentlawyer.ca. That's pocketemploymentlawyer.ca, and find out. Use our severance calculator. Find out how much severance you may be entitled to in the circumstances. And that is a very simple tool to use. Very little information is required there to get an initial assessment. Of what your potential severance entitlements will be. And they will be, again, if it's the case that the employer is trying to claim an at-will employment situation, it's going to be significantly greater, than the zero number basically that at-will employment provides for, significantly greater than that. So absolutely, please use the severance calculator to determine that initially. And for further questions, of course, you can have all our contact information at employmentlawyer.ca to reach out to our team. We are standing by, of course, to answer your questions and to get a clear and firm assessment on your situation, your severance package. So thank you again for that very useful question. Very helpful question, again, because many employers are U.S. based. They may not have the same appreciation for Canadian, the rights of Canadian employees who reside in Canada, as Canadian companies or companies who are primarily based in Canada may have. So thank you for that. Again, my name is Sephton Leibbrandt. I'm an associate with Samfiru Tumarkin, LLP. We are the employment lawyers. We are answering your questions here today live. So thank you again. I see a bunch of questions coming in here. Our next question is from, looks like from YouTube, from Linda. She asks, when is an employer allowed to ask for a doctor's note for taking sick leave? Can they require a note after 1 day of sick leave? So the short answer, Linda, is yes, they can. They can require a doctor's note in these circumstances. Again, the doctor's note doesn't need to be very detailed. It simply needs to indicate that you cannot work. It doesn't need to provide personal details, confidential details about the medical situation that you are experiencing. But the short answer is, even after a very brief sick leave, to demonstrate that that sick leave is, of course, legitimate, the employer is entitled to a doctor's note. Again, the doctor's note does not need to be expansive or detailed in any manner whatsoever. It simply needs to, set out that you cannot work on that particular day, and that's basically it. It doesn't need again to provide particular information about your medical condition or diagnosis or anything like that. That's all confidential information. Your employer is not entitled to that kind of confidential information. That's yours to keep, and between you, of course, and your doctors. But in terms of the note, yes, unfortunately, the case is even after a very brief sick leave, to demonstrate, of course, that that is a legitimate request and it was a legitimate request, they can require a note from your doctor. So it's best to just go and get that. Again, it's usually a very simple process, and in terms of the note itself, it's very, very basic. They don't need to know, what exactly was happening with your medical situation on that particular day. It's simply that your doctor advises you cannot work for that day, and that's that. So it's really that simple. So thank you for that question, Linda. A good question, and a useful question, because on, of course, a broader topic, I often receive questions from employees about issues with respect to their work in terms of an employer asking for very, very significant and detailed medical information about their condition and things like that. The long and the short of it is, if your employer is asking for those kinds of things, typically they're not entitled to that kind of information, not about your diagnosis, not about your medical condition. That is not what is relevant to them. It's simply about, can you perform your job? Can you work, or are you sick? If you are, sick and your doctor is saying you're sick and you cannot work, that is sufficient. It's not, they don't need to know anything further than that. The rest is, confidential information there. So thank you again, Linda, for that question. And thank you, because it's a very important and useful question for everybody, I'm sure, to know about. We are getting now to the end of our time, but perhaps we have time for one more question here. It looks like ST Bean 2 from YouTube is asking, what happens if your employer is refusing to provide workplace accommodation? They've said it's not something they allow. I just need to be able to take 10 minutes a sitting break or so every half hour or so, or every hour or so. I can work while I'm sitting, but they say it is against policy. So that certainly sounds, ST, as a concern potentially from a discrimination standpoint. If it's the case that you have, a doctor's note saying you need, for instance, to sit for 10 minutes and they are not permitting accommodation, that sounds to me like, on its face, that may be contrary to the Human Rights Code, and there may be discrimination there. Employers have an obligation to accommodate one in employment, and the threshold not to do so is very, very high in this circumstance. Without knowing the full details of it, just very basically and simply, an employer has to accommodate you. If you request accommodation, in this case, it sounds like it's a very minor accommodation, against company policy. It would depend on the nature of your employment there. If there was really a very pressing reason as to why you absolutely had to remain, standing for the entire, period of your work day, perhaps it could be the case. But again, it would simply have to be a very, very clear and demanding position to warrant that kind of thing. I can think of very, very few scenarios where that would ever be the case. It sounds like, to me, at least necessarily on its face, that may be indicating, that they are failing to accommodate you contrary to their obligations under the Human Rights Code. But definitely, to get more understanding of, full assessment of the situation, please reach out to our team, employmentlawyer.ca. Please reach out to us to get an assessment, understanding of what the situation may be and what exactly is going on here, because there may be an issue with their failure to accommodate you under the Human Rights Code here in this circumstance, because it sounds to me, again, initially, that really a 10-minute sitting break every hour or so is not significant, not material, not going to affect anything materially with respect to your work. And if you especially have a doctor's note, to demonstrate that that is required, then absolutely, in my view, they should be accommodating that. So thank you for that question, ST. it looks like we are now near the very end of our time. We may have time for one potential final question, but we've got a bunch of questions today, and I'm very, very happy to see that. So thank you for everybody who has reached out on multiple platforms here to ask questions about their employment situation. We greatly, greatly appreciate it, and it's very, very helpful to, of course, not only yourselves but anybody potentially tuning into our live stream here to get the information that they require. So thank you, very much again for all of your questions today, and thank you for joining us on the Employment Law Q&A live. We will be answering your questions going forward on a regular basis. You can see our schedules below on YouTube, for instance. So please join us again if your question did not get answered today. And we would also appreciate it if for instance, you're on YouTube or Facebook, to like and subscribe to our channel. Thank you very much for joining us today. Our next show will be coming up, I believe, October the 9th, 1 p.m. with Lior Samfiru, managing partner, co-founder of Samfiru Tumarkin LLP. So thank you for joining me. It's been a pleasure. Sephton Leibbrandt as associate Samfiru Tumarkin LLP. Thank you very much for joining me again today, and hope you have a good rest of your day. Take care now.